Hello, my name is Michael Tesoro, and I prepared this video case note on two recent cases, the Commonwealth Director of Public Prosecutions versus Alkaloids of Australia and the Commonwealth Director of Public Prosecutions versus Joyce. And these two cases arise out of a hardcore cartel which the ACCC investigated and which the DPP commenced a prosecution in relation to. And both Alkaloids and Joyce pleaded guilty to the charges, and so it went to a sentencing hearing. And so these two decisions are the sentencing decisions of Justice Abraham of the Federal Court. A bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice, Sarah Lee Consulting, for the last 14 years, and I help companies with competition and consumer law matters. I've also helped a few companies, individuals with ACCC cartel, criminal cartel investigations, so I've gained some insights into the process through that work. And prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement, and I did run some civil cartel investigations and litigation, but the criminal cartel provisions hadn't been introduced when I was at the ACCC, so I never ran one of those cases, although I did run a couple of criminal prosecutions in relation to other provisions of the legislation with the CDPP. The outline of the presentation start with some background, then the chronology, then look at the charges, and then spend most of the time discussing the sentencing decision of Justice Abraham, and then finish with some commentary. Now, Alkaloid is an Australian company which produces this product, which is quite difficult to pronounce, but fortunately it's also known as SNBB, and it's a product that's extracted from a particular plant, the Dubiosia plant, and it's actually the active pharmaceutical ingredient used in medications to treat abdominal pain, spasms, and renal colic. And effectively, SNBB is sold to be included in these anti-spasmodic medications, the main one being the brand Buscopan and its generic alternatives. Now, it's important to recognise that virtually all of Alkaloid's SNBB was sold to export markets. So between July 2009 and December 2018, Alkaloid sold approximately 29 tonnes of SNBB, and all but 6 kilograms went overseas. So basically only 0.02% of Alkaloid's SNBP was sold to Australian customers. So as concluded by the judge, there was no material market for SNBB in Australia. So Christopher Joyce, he was employed by Alkaloid as their export manager, and he appeared to have full responsibility and authority over all aspects of the marketing and sale of SNBB. Significantly, he seemed to have total discretion over pricing. Joyce was employed as an independent contractor and was paid a retainer and a commission. So the commission is relevant because, I guess, being a price fix, if the price goes up, Mr. Joyce ends up earning more commission. And Joyce reported to the directors of Alkaloid, and Alkaloid was a family business owned by the Crumptons. So it was found that he reported to the Crumptons and kept them informed of all matters relating to the marketing and sale of SNBB. And relevantly, he was found to have advised them of the pricing arrangements between Alkaloid and its competitors. Now, the chronology, the charges start from the 24th of July 2009, which is also the same date that the criminal cartel provisions came into the legislation. So what had occurred here is that the conduct started before the criminal cartel laws were brought in and continued after that date. So obviously the individual and the corporation could not be charged for conduct that predated the introduction of the criminal laws. And it appears from the charge sheets that the conduct ceased in June 2017. On the 1st of December 2020, Alkaloid and Joyce were charged. On the 26th of October 2021, Joyce pled guilty to the charges. On the 16th of November 2021, Alkaloid pled guilty to the charges, and then the sentencing decision came down on the 29th of November 2022. Now, important thing to understand is the idea of the rolled up count, and the judge explains it there, but it has its origin in the common law rule against having a duplicitous charge sheet. So the principle in the common law is that each charge should only include one offence, and if there was more than say 2 or more offences in a charge sheet that could be duplicitous and cause the defendant unfairness. It could be unfair to the defendant to have more than one offence in a charge, because it would make it somewhat difficult for them to defend themselves. So it's really based on being a matter of fairness, that a person who's charged with a criminal offence is entitled to fully understand the charge and the crime they're alleged to have committed. So effectively, when there's charges are drafted, the idea is to either have one offence per charge, or to try to use one of the exceptions to get around that particular rule. And I guess the practical consequence of this is that there's a lot of offences. It's going to end up being a very long list of charges. It's going to make it more difficult for the defendant, more difficult for the prosecution to run the case. So obviously what sometimes happens is that the prosecution drop a lot of the offences and just focus on a lesser number of offences. But one of the exceptions around the rule is the rolled up count, and that can only occur when the defence actually consents to the rolled up count. So as you can see there, the approach is adopted in some cases where there is a guilty plea and where there is consent of the offender's counsel. For otherwise, the accounts would be regarded as duplicitous. So what happened here was obviously the DPP sought the consent of the defendants to having a rolled up charge. And the key to the rolled up charge is there still is only one offence, but then there's a number of other offences that are included in the count, which provide, I guess, context for the conduct that occurred. And the maximum penalty doesn't increase. So in this particular case with the corporation, there'd be the maximum penalty applying to the first offence, and a number of rolled up charges would be included in the count, but they wouldn't be subject to additional maximum penalties. Rather, what would happen is the judge could look at the whole, the primary offence and the rolled up charges, and get a better impression for the objective criminality of the defendant. So I guess what that means is that if there'd just been the one offence, the judge might have concluded that it was at the lower end of the scale in terms of severity, but once they consider all the rolled up charges, they'll see that it's part of a broader range of conduct, and accordingly a higher penalty would be appropriate. So if you look at count 1, you see that there was a primary count which had an allegation that between July 2009 and June 2017, Alkaloid intentionally gave effect to a CAU, which is a contract arrangement understanding, which had been reached with its competitors, Alkacorp, Alchem, Boehringer, Linear, Vital and Chemimac. And the purpose of this cartel provision was to sell SNBB at a minimum price between $1,500 US per kilo to $5,000 US per kilo. And obviously the purpose of that was to fix, control and maintain the price of SNBB. So that was the primary offence, but rolled up with that offence were 7 further price fixing offences, where Alkaloid had gave effect to those 7 price fixing provisions in different contract arrangement understanding. So effectively there's 8 offences in this first count, but only one of which is subject to a sanction. That wasn't all. There was actually a further 2 offences rolled up in count 1, and the first was making a contract arrangement understanding with a cartel provision, and also an attempt to make a CAU. So as you can see, in this first count there are actually 10 offences. And then Mr. Joyce was charged with aiding, abetting, counselling or procuring Alkaloid's contravening conduct. Now count 2 occurred between December 2010 and July 2012, when Alkaloid intentionally gave effect to a cartel provision that had been entered into with a few of its competitors, Alkacorp, Boehringer, Linear and Alchem, and effectively it was to acquire the entire supply of Dubosia leaves from this grower David Tham and further to obtain a commitment from Mr. Tham there would not grow, produce or cause dubosia to be grown or otherwise produce from his property. So obviously what was happening here, there was agreement to buy up all this particular grower's production and then stop him being a supplier to the market. And the context of this was a concern that Mr. Tham might have been interested in selling to a new entrant to the market, which would have no doubt destabilised the cartel. There were also some rolled up charges in relation to count 2. There was one additional rolled up charge, which is an attempt to induce others to make a CAU with a cartel provision. And again, Mr. Joyce was charged with being an accessory to this count. The final count was an attempt between Alkaloid and Alkacorp and Chemimac to effectively introduce two things. Firstly, a pricing structure inversely tiered on the basis of the quantity to be supplied, which set a minimum price of $1,500 US per kilo specifically to customers in Bangladesh, and obviously that was for the purpose of fixing, controlling and maintaining the price of SNBB. But there was also a second element to the agreement, which was effectively a customer allocation agreement, whereby these customers in Bangladesh, Fissens, Opsonin and Essential Drug Company would be allocated to Alkaloid, Alkacorp and Chemimac respectively. So there was a price fixing agreement and a customer allocation agreement in this particular count. And again, there was 4 further offences that were rolled into that primary offence. And as you can see there was making a contract arrangement and understanding between 2011 and 2012, giving effect to cartel provisions, and furthermore giving effect to a further cartel provisions. So again, you can see that there's effectively 5 offences, possibly 6, included in this particular count. And again, Mr. Joyce was charged with being accessory. Now, the approach that the judge takes to sentencing criminal cases was set out, and the first thing is the guidance of balancing all the different factors and conflicting features to arrive at the appropriate sentence, and the decision in Makarian that it's an instinctive synthesis, it's not a mathematical exercise, and what it involves is basically the judge identifying all the factors that are relevant, balancing them all up, and then making ultimately a value judgment as to the appropriate sentence to impose. So the considerations the judge looked at in relation to Alkaloid was firstly that it was a global cartel which had international impacts. Also, Alkaloid had been very active through Joyce in monitoring the cartel and policing other parties' compliance with the price fixing agreements, largely the prime mover in the activity as far as the evidence suggested. There had been some cheating on the price fixing agreement, but that didn't help Alkaloid or Joyce in any material way. There'd been an argument that the fact that it was cheating was somehow a mitigating factor, but that was not accepted by the judge. The offending conduct occurred over a very long period of time and could only be characterised as deliberate, systematic and coordinated. The relevant agreements were given effect to repeatedly rather than as a one-off, and quotes were given consistent with the price fixing agreement in a number of countries to various customers. The ongoing course of conduct in respect of the agreements continued with the exception of some gap between September 2012 and March 2015, and that's in relation to one of the particular counts. And the conduct was covert in nature, so they obviously kept it hidden. So one issue that was argued by the defendants was that the conduct hadn't had a very significant impact on Australian consumers, mainly because very little of this product was sold into Australia. But the judge didn't accept that argument. She looked at it from probably a bigger picture approach. She noted that the conduct was destructive of competition, that effectively it, by not supporting competition and by engaging cartel conduct, it would protect inefficiency and cause market distortions. Also, she concluded it was corrosive to the economy generally and to international confidence in Australian businesses. So this idea that the cartel activity would actually damage Australia's trading reputation, and that it necessarily impacted on the Australian economy and the welfare of Australians. So she didn't accept the argument that the effects on the Australian market had been negligible. Then there was a question of knowledge, and Alkaloid claimed that they didn't really know what Joyce was doing, and it was a strange submission to make because it seemed pretty clear on the evidence that they had a good understanding. And there you can see the judge noted that John Crumpton had knowledge of the 2009 Madrid CRU. There were email exchanges where Joyce referred to the price fixing arrangements, made a reference in one of the emails to the fact that they were sticking to the quantities and price, and that it says that Mr. Joyce informed Mr. Crumpton of the agreement regarding price in his email of 19th of October 2009. So there was clear evidence that the Crumptons were aware of what Joyce was up to. The other factors the judge took into consideration is that Alkaloid appeared to have a poor record of compliance in terms of the absence of a compliance program. What they sought to explain to the court that they had quickly introduced a competition and consumer law program, I guess it was seen as a little bit too late, but also the evidence that was provided in relation to that was not in affidavit form, which meant that there was no cross-examination to find out exactly how much commitment had been given to compliance. Also, there was no evidence that been cooperation in the past or any commitment to providing cooperation to the authority in the future, so there couldn't be any discount for that aspect. Then the guilty plea is an interesting one because even though the process here is one of an instinctive synthesis, the exception to that general rule is the discount given for a guilty plea. That sort of stands outside the instinctive synthesis process. And the courts have found that it's important for transparency to state the percentage discount that has been provided for a guilty plea. So in this particular case, she gave the Alkaloid a discount of 25% for their early guilty plea. Then she concluded there were reasonable prospects of rehabilitation, but again the problem here was that there was a letter given to the court outlining that they were contrite, they were sorry for what happened, and other arguments of that nature. But because it was a letter and not in affidavit or sworn form, she didn't give it as much weight. Clearly, if you're going to put some evidence on, you need to do it via an affidavit, because then you'll be able to cross-examine and open to scrutiny. Here there might have been a strategic decision that they didn't really want anybody going on affidavit because they'd be cross-examined, so there might have been a good reason just to provide a letter. But I guess if you want to get weight for such things as rehabilitation or for your compliance program, if you want to get full weight for those issues, then you have to put an affidavit on and subject a senior executive to some cross-examination. Also, she concluded that the character and antecedents were favourable to Alkaloid. However, because she was focused on general deterrence, they were given less weight. And then she put quite a bit of weight in the fact that it was a moderately sized family owned and operated Australian company. So it wasn't a huge business, it was quite a small business. But that they did make an argument that a very large penalty would cause it significant financial damage. Again, she didn't accept this evidence or give it a whole lot of weight because of the form it was entered into. Again, it wasn't put on in affidavit form, which allowed some cross-examination. So again, not getting the full benefit of the arguments by not putting sworn evidence on. So the disposition of the judge, and it's a long quote here, but it just summarises all the factors that she weighed up. The conduct occurred for a very significant period of time. It was deliberate, systematic, coordinated and covert. It affected the price of these products for customers all around the world. It was a global impact, and significantly Alkaloid, through their agent, was very, very actively involved in monitoring the CAU. So he was there policing it and making sure that everybody else stuck to the agreements that were made. She also concluded that because she was focusing on general deterrence as the primary sentencing consideration, some of the subjective factors were given less weight, and clearly she had to impose a penalty which would convince other companies that might be minded to break the law that the penalty was not simply a cost of doing business. It had to be large enough to deter other companies from engaging in breach of the law. And as I said earlier, she provided less weight to various mitigatory factors because she was really looking at the achieving general deterrence. So looking at the subjective factors, there was some weight given to those, the compliance program and contrition. Again, as I said earlier, the way these are presented to the court will have some bearing on the weight given to them, and if you give this evidence in a sworn form, it's going to get more weight than if you put it forward in a letter. And one factor that hurt Alkaloid was their attempt to distance themselves from Mr. Joyce in their evidence, and she concluded that it was clearly not accurate to make that claim, that they failed to exercise proper control over Mr. Joyce and they had knowledge of various aspects of the illegal conduct. So what she concluded was that a conviction was recorded against Alkaloids for each of the 3 offences which they pleaded guilty to, and she concluded that she gave them a discount for their guilty plea of 25% of the maximum of the penalty she would have imposed otherwise, and she imposed penalties of 1.5 million for count 1, which is clearly the most serious contravention, most long-running, probably the most damaging. Count 2 was the one that had an impact specifically on Australian grower, so that was $375,000, and the final one, which was the attempt, was the lowest penalty, count 3 of $112,500. So the total penalty imposed was 1.9 million, which is a sizable penalty. And just turning to Mr. Joyce, the first issue that was noted was that he made a financial benefit from the fact that there was a price fixing agreement. He was paid a retainer of $9,500 a month, but then he was paid a commission of 2% on Alkaloids SNBB sales revenue. So as you can see, once the prices were pushed upwards, he made larger commissions. So clearly the strong implication was that he engaged in legal conduct for financial gain. Also, a factor that hurt Joyce quite a bit was his active monitoring and policing of everybody's adherence to the price fixing agreements. The judge concluded that he'd been forceful in advocating compliance, that he'd been sending emails and calling people up and making sure that they stuck to the deal. And so that was a factor that obviously made him more of a prime mover in the whole price fixing arrangement. Now, the effect on Australia was one thing that the judge rejected, and she rejected it on the grounds mentioned earlier with Alkaloid, just on the general impact on competition and on Australia's trading reputation. But she also pointed out that clearly count 2 was very focused on Australia because it impacted Australia by seeking to remove a Dubosia grower from the market, and it also would have prevented a 7th player from entering the market who wouldn't have been part of the cartel arrangement, and if this 7th player had come into the market by being able to buy product from this grower, Mr. Tham, then that entry could have destabilized the cartel and resulted in the whole thing falling over. So that was a significant impact specifically on Australia. She comments there that it had a distortive effect on the Australian economy. So the arguments that there was very little impact on Australia didn't get much chop from the judge. The other factors she looked at in relation to Joyce was the discount for an early guilty plea, and again she gave him a 25% discount. She also noted that he cooperated with the ACCC by giving interviews, providing an induced statement, and giving an ongoing undertaking to cooperate. She concluded that his past cooperation had been of pretty low value, mainly because he had very bad recollection of events. A very significant factor, I think, in the ultimate decision was his age. He was 74 years of age, and she quotes this decision or this statement from R.V. Hunter, where the judge said, "A sentencing judge cannot overlook the fact that each year of the sentence represents a substantial portion of the period of life which is left of the defendant." So you can't ignore the fact that if you sentence somebody to jail, that if they're elderly, that it's going to be a significant proportion of the remaining years. She noted there were no prior convictions, and also that he was of good character, with the exception of this particular conduct. Then she concluded there were good prospects of rehabilitation. That was based on a sentencing report which had been prepared and given to the court, and that was confidential, so I don't know quite what it said. I think that's a significant factor. Also, he consented to being disqualified as the holder of his position as a director of different companies. He appeared to be generally remorseful and contrite, and I guess generally is suggesting that he wasn't maybe as remorseful and contrite as he could have been, but he seemed to generally regret what had occurred. And these are two significant things which are mentioned just in passing, but it seemed he cared for his 95-year-old mother, who was largely immobile, and he was also caring for his wife during a recent diagnosis and treatment. So it obviously sounds like his wife is quite ill and he's looking after her. He also pointed to some other detriments which he'd suffered as a result of this case. Firstly, he declined appointment as a member of the Order of Australia, so obviously that had been offered to him recently and he'd said no. He also had to resign from a number of board positions, including one he founded, Nuts for Life, which I'm not too sure what they do, and also significantly a loss of professional reputation. So all these factors are relevant to the sentencing decision. So the disposition was really focused on what was the director's position on some of these submissions made by the defence. And clearly the role of the DPP is to tell the judge when the judge may be considering a sentencing option which would result in appellable error. So they will often point out to the judge that a particular sanction that's being considered by the judge is outside the appropriate range and it shouldn't be done. But otherwise they're fairly quiet when it comes to presenting submissions. And here what was relevant was that there was agreement both by the DPP and by Joyce that a sentence of imprisonment was the only appropriate sentence. So that was the first issue that was agreed. But then when a submission was made by Joyce's lawyers to the court that it could be served as an intensive correction order, the director did not make any submissions against that. So effectively the director indicated to the court that a decision by the court to effectively sentence Mr. Joyce to a period of imprisonment to be served as an intensive correction order would not be an appellable error and they would not be complaining about it. So when that occurred, it seemed fairly obvious that the judge would head down that direction. Now, the judge considered that the offending conduct was clearly highly anti-competitive, very significant period of time it went on for, deliberate, systematic, coordinating, covert, repeatedly given effect to, had a global impact. Mr. Joyce was actively involved in monitoring, policing the CAUs, enforcing compliance, making sure that everybody towed the line. She also concluded that he'd done it to advance the financial interests of his employer and himself. And this is an important point. He had given some evidence in an affidavit that he didn't know the conduct was illegal, and some reference there to the fact that it was like an export cartel. But when he got in the witness box and was cross-examined, it became apparent that he knew his conduct was improper in relation to count 1, and then in relation to count 2 he actually gave evidence that he believed it was unethical and probably unlawful. So there's sort of contradiction in his evidence from his affidavit to what he said in the witness box, and that obviously counted against him. He had knowledge that what he was doing was wrong, and as a result the penalty had to be more severe. So what she concluded was that there should be a period of imprisonment of 32 months, and it's required that she indicate how much she is imposing in relation to each count. So in relation to the first count, which was clearly the most serious count, she imposed a penalty of 26 months, and that represented a 30% discount of the amount that she would have imposed, and that's for both the guilty plea and past assistance. So basically he received 25% discount for pleading guilty and a further 5% discount for the past assistance which he'd given to the ACCC, which, as was mentioned earlier, wasn't very strong assistance. Then in relation to count 2, she concluded that a period of imprisonment of 8 months, again with a 30% discount, and the final one, which was the least serious, obviously involving an attempt, a period of 4 months with a 30% discount. The other thing she's required to do is to indicate whether there was any concurrency between the indicative sentences, and she said that there was some concurrency between the various sentences, and she also had to indicate in respect of the future assistance that he was proposing to provide. And clearly if he hadn't been proposing to provide any future assistance, then there would have been a higher penalty, and she's required to say what the higher penalty would have been. So she notes it's a very speculative exercise, but had it not been for the future assistance which Mr. Joyce had said he would provide, the sentence would have been 2 months higher, would have been 34 months. So she mentioned there was a sentencing assessment report which said that Mr. Joyce was a suitable candidate for such an order, and that he would be suitable to undertake community service work. He had a low risk of reoffending. Clearly he wasn't considered to be a danger to the community. So she concluded that the sentence should be served by way of ICO, Intensive Corrections Order. And here what she's decided, there's a variety of orders that you can make. Clearly the most extreme one would be home detention, but you can also impose curfews on people, that they can't have to be home at a certain hour. And the lowest level one is effectively that you do community service and sign in with a parole officer or a community corrections officer. Now, that's the one she decided, which is the lowest level one. She decided that there be a requirement that he undertake significant community service work as directed by the community corrections officer, and she decided on 400 hours. Now, one thing that was sort of interesting was he made no submissions to the court about whether he should pay a fine and his capacity to pay a fine. So the judge took it that there was no objection to her going ahead and imposing a fine. Clearly the Director of Public Prosecutions wanted a fine, so she decided to impose a fine of $50,000 in relation to count 1. And then finally there was an order disqualifying Mr. Joyce for managing a corporation for a period of 5 years. So as you can see, when you summarise all the various orders, conviction was entered in relation to the 3 offences to which he pleaded guilty. An aggregate sentence of 32 months was imposed commencing 29 November, and that was to be by an intensive corrections order, which involved him obviously not committing any further offence. If he commits an offence within the relevant period, then he could be sent to jail, and he must submit to the supervision of a community corrections officer. He's got to perform community service of 400 hours. He's got to pay a fine, and he's prevented from being or disqualified from being a manager of a corporation for 5 years. Now, it's an interesting case. I think it clearly is a hardcore cartel. It's not only been going on for a very long period of time, in excess of 10 years, but it's comprehensive. It involves every competitor in the market. It had various aspects to it. There was price fixing, there was customer allocation, there was attempt to reduce supply of product by stopping Mr. Tham from selling his product to any new entrants. So this is really what the criminal cartel provisions are all about. I think the sanctions for the corporation were quite appropriate. I guess in relation to the individual, there's a question mark as to whether that was an appropriate sanction, because it's hard to visualize a more clear-cut case of an individual engaging in a hardcore cartel. You have an individual who was instrumental in entering into a variety of agreements, very, very strong on enforcing these particular agreements, policing the agreement, obviously gained significantly financially from his conduct, and he didn't end up actually going to jail. And so you're just wondering, in what situation will somebody go to jail? There's some lessons learnt in this case. Clearly, if you're going to argue such things as contrition, that you've implemented a super duper compliance program and so on, and also that the penalty might have dire financial consequences for your business, you have to do it through a sworn statement and open up an executive to cross-examination if you want to get full weight for those submissions. If you just put a letter or a report onto the court's going to give it very low weight because it hasn't been subject to the scrutiny of cross-examination. So strategically, you've got to work out whether it's better to just put a letter on or a report on and get less weight and not expose a senior exec to cross-examination, or whether you'll take that chance. In this case, maybe it was thought wiser not to put any executives in the witness box and subject them cross-examination. So that's a clear strategic decision that might have been made. There were many questions left unanswered here. I think the judge's reasoning for why she decided to impose an ICO were not very clear at all. I have a strong feeling that the major factors which led her to electing that particular outcome were, firstly, that he was 74 years old, secondly, that he was caring for his 95-year-old immobile mother, and thirdly, that his wife was obviously quite sick with some serious condition. So he was the primary carer for a couple of people, and if he'd gone to jail, there would have probably been nobody available to care for those people. So I have a bit of a feeling that maybe in the sentencing report there was more discussion of these two issues, and the judge put quite a bit of weight on those factors. But it really, I think, would have been more helpful had that been spelled out in her judgment. Really, we just don't understand how she moved from where she was to an ICO which sees him not going to jail at all. I think there's some other unanswered questions, just what's happening with all these other companies that are involved in the cartel with Alkaloid. It doesn't seem there's been any activity by the ACCC in Australia. Clearly some of the conduct did impact Australia, and you would expect that some of investigations occurring overseas, given that a number of these cartel provisions were entered into in various countries such as Spain and Switzerland. There was the Madrid Agreement and the Geneva Agreement. So it's surprising that there hasn't really been any news of any investigations overseas. So I think that's really an interesting case, but it's just a bit disappointing that the reasons for the ICO weren't more fully explained, and you have to be left asking yourself the question, if an individual like Mr. Joyce, who was really a prime mover in a hardcore long-running cartel, doesn't go to jail, who's going to go to jail for a cartel offence? That's all I had. If you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.